Andrew McCarthy, former assistant U.S. attorney and former federal prosecutor. He's also a Fox News contributor. Andy, your take, what you thought about these opening arguments that we heard from both sides?
Martha, I'm struck by the juxtaposition between the positions that the lawyers on the competing sides are taking and the way that their rhetoric, interestingly, at times undermines the position that they want to take. So, for example, Adam Schiff, on behalf of the House managers, makes the argument repeatedly that the case that the House made against the president is overwhelming. And he does that in the context of trying to make an argument that they need evidence and witnesses. They called the evidence, he called the evidence that they're, the new evidence that they're asking for at various times, vital and crucial. He referred to the witnesses as key witnesses. Of course, it's not possible, if the evidence is already overwhelming and the case is already overwhelming, that they could have made an overwhelming case without substantial evidence that was vital and key and crucial. So I think his rhetoric is running into his position. At the same time, on the president's side, the president, while I think the president's lawyers quite rightly are emphasizing the constitutional infirmity of the two charges, the president wants to contest the facts of the case. And some of that has seeped into the rhetoric of his lawyers. The problem I think he has with that, and this is something I think they'll have to be concerned resonates with these moderate Republican senators, is if the president is taking the position that the facts need to be contested, that whether there was a quid pro quo and whether he did anything wrong needs to be contested, that actually supports the argument for why you should hear from witnesses who haven't been heard from yet and who may have things to say that are relevant on those different subjects. Now, they can make the argument that the House should have called those witnesses or made a better effort to get them, but the fact is that the rhetoric of contesting the facts is supporting the argument of the people who say that more witnesses are necessary.
Yeah.
Andy, what about the Schiff argument about fairness? We covered that committee hearing. Obviously, it was exactly opposite, as Republicans were saying his operation was not fair at all. Yeah,
it's interesting, Brett. You know, I think the perhaps the unforced error that Senator McConnell made was not allowing the record in the House to be brought in toto into the Senate, which would normally be a kind of a pro forma thing. But it was clearly done for the reason of trying to highlight what they perceive as the unfairness, and I think with good reason, the unfairness of the House proceedings. I really thought that they could have made that point without leaving themselves vulnerable to claims and complaints about not bringing the whole record in. Lawyers always talk about the difference in a trial between the weight and the admissibility of evidence. And what that really means is you can let evidence come in, even evidence that the underlying authenticity of which or the procedures supporting which are a little bit shaky, and make the argument that that evidence should not be accorded great weight because of the way it was collected or because of other attendant circumstances about it. I think he should have probably just allowed all that stuff to come in and let the lawyers make the argument that the House proceedings were unfair.